Siseko, we still audible.
Yes, you are. But the video that you are playing, I still can't hear, but your mic is clear.
Recording in progress. Recording stopped.
Good morning, members. Good morning, Chair. Chair, we are ready. The time is just after 10. We have the quorum. I think the meeting can begin. I hand over to you, Chair. Thanks.
Thank you. Good morning, everyone. I wanted just to show my face so that I can close my video. Honorable members, let me take this opportunity to welcome members of the committee, the affected members,
Recording in progress.
the initiator and his team, and the legal team of the affected members. You are all warmly welcome into today's meeting. I don't know whether we do have apologies before us. I will be advised by you, Andile.
No apologies, Chairperson.
Thank you. If there are no apologies, we'll have to proceed. Honorable members who are today and the next 2 days holding a hearing on the SONA incidents of the 9th of February 2023, which the Speaker referred to this committee for investigation and report. I now declare the hearing open. I will ask the initiator to introduce himself and his team and to inform the committee of the purpose of the hearings. Over to you, initiator.
Thank you. Thank you, Chair. My name is Anton Katz. I'm a senior counsel and I'm the initiator, having been appointed as such by the State Attorney. I am assisted with the initiation and the evidence leading by Ms. Advocate Jade Aspling. She's immediately behind me on my right, and behind her is the State Attorney, Ms. Onel Marsh-Scott. Immediately next to me is the Parliamentary Legal Advisor, Mr. Andile Tetiana. The other members of the team who are assisting is Mr. Victor Ngaleka and Mr. Molisi Totti. They are sitting on my right, 2 seats away, and Mr. Totti is opposite me, who will be assisting with the protocols that are served today. We as the initiating team are ready to proceed. We're ready to put the charges to the 6 affected members. They received their notices of the hearing on Tuesday, the 7th of November, 2023. And perhaps before I take that step, perhaps I should just make 2 observations. The one is that 2 days ago, less than 36 hours ago, the legal team for the 6 affected members, who are all present in the chamber today, launched an application for a postponement of these proceedings. And before I ask them to introduce themselves and to motivate the postponement, if with the permission of the chair, perhaps I should just outline in 30 seconds what today's proceedings are about. The charges, as chair, you have correctly pointed out, relate to the events that happened on the 9th of February 2023 during the State of the Nation address by the President of the Republic of South Africa. And perhaps in 10 seconds, I may put on the screen that which happened. Immediately thereafter, I will hand over to our learned colleagues to introduce themselves and to then indicate their stance. Chair, after the short video, I would propose that you make a ruling that the legal team for the affected members take 30 minutes to motivate why the matter should be postponed without interruption by the committee members. I would then have 30 minutes to rebut their application for a postponement, and they have 10 minutes in reply to deal with anything that I've raised in my rebuttal to their application for postponement. Thereafter, the committee members could address any questions or queries they may have to the respective legal teams. So may I ask that the short clip
On
be
a point of order.
played.
Point of order.
What is the point of order, Honorable Malema?
Chair, it is not the responsibility of the initiator to want to tell us how we're going to run the proceedings here. You can't tell us who's going to speak for how many minutes and who's not going to interrupt that person and who's going to respond for how many minutes. You can't tell us that. It's got no role to tell us that. It's your responsibility as a chair after the consultation with the team. You see, it's a problem, this thing that you hire minorities when you're charging Africans here. You did that with public protector. Now you brought a white man here who's coming to tell us what to do. We're not going to
Honorable
accept that.
Malema, can
It's
you
a
please
responsibility
can you-
of a committee to
can you
tell us
please make
how
a
we're
point
going
of
to run
order so that I
proceedings.
can make a ruling?
Make a ruling. Make a ruling. But this thing
Then-
of bringing white people, when you are charging us, you bring white people to come and prosecute us. We're being prosecuted by white men here, a white male.
Honorable Malema, can you stop there because you have made your point and I've heard you. I will make a ruling as the chairperson. Initiator, can you stop there? I will proceed with the chairing of the meeting. And I have acknowledged your point of order is sustained. I will make a ruling as the chairperson. Now I'm proceeding. I now ask the legal team because he has introduced himself and his team, I'm now asking the legal team of the affected members to introduce themselves. And after the introduction, and make their application. I will give them 30 minutes, of course, to motivate I'm allowing that. But before that, the legal team of affected members confirm with me the presence of all the affected members in the August House. Over to you, my legal team of affected members.
Thank you, Madam Chair. My name is Tembeka Ngugaitobi. I'm an advocate in Johannesburg. I am in this matter with Mr. Ramohale and Ms. Sekwe, S-O-E-K-O-E. We act on behalf of Mr. Malema, Mr. Shivambu, Mr. Ndlozi, Mr. Dlamini, Mr. Pambo, and Mr. Tambo. I presume that they are all present. Mr. Malema has already announced himself, and I've seen the name of Mr. Shivambu on the screen. And perhaps we should simply ask Mr. Ndlozi, Mr. Dlamini, Mr. Pambo, and Mr. Tambo to confirm their presence, because I've not personally seen them.
Can you do so, honorable members, as requested by Advocate Ngugaitobi?
Thank you very much,
Just
Chair.
to confirm.
Pambo. Thank you very much, Chairperson. Guyani Pambo here. I'm present.
Thank you.
Chair, I'm present, Marshal Dlamini.
Thank you, Dlamini.
That leaves Tambo and Mr. Ndlozi.
Thank you.
Chairperson, I'm here, Ndlozi.
Thank you, Dr.
Thank you, thank you, Madam Chair. If I may then proceed, there are two applications that we've indicated we intend making. The first application is for the committee to appoint an independent chairperson who might either be a judge, a senior attorney, or a senior advocate to conduct the fact-finding inquiry, and the matter will then be remitted back to the committee for its final determination. That's the first application. The second application is for these proceedings to be postponed to either a date or dates in January or February. We will be indicating to our learned friends the week in January or February that would be suitable. Let me start with the first application, which is the appointment of an independent chairperson to conduct the fact-finding inquiry. Firstly, the committee is bound by the common law rule against bias. Now, we don't accuse the committee of bias, but what we say is that the common law rule against bias means that you as a committee cannot be a judge in your own cause, and that it is important that there should be no perception, reasonable perception, that you are biased against the EFF. Secondly, you are bound by the provisions of Section 12 of the Powers and Privileges Act. Those provisions require you to ensure that the proceedings are reasonable and procedurally fair. We say that the only way to ensure that there is reasonableness and procedural fairness is that you should appoint an independent chairperson to conduct the fact-finding inquiry. And thirdly, you are bound by the Constitution, and I need not say that, it's obvious. But the requirements in Section 1C of the Constitution require you to ensure that you act rationally. And we say that the only way to act rationally in these instances is to appoint an independent fact finder. So let me start then with the first of those three propositions, the rule against bias. Now, the rule against bias is part and parcel of the common law rule of audi alteram partem, which is generally referred to as the natural justice. What it contains are two elements. The first element is that you should give a hearing to an affected party. Obviously, you are giving us a hearing. We are not objecting to that. But the second one is that the person who hears the matter should not be biased and should not be reasonably perceived to be biased. The problem that you have as this committee is that you are majority, according to the calculations of my learned colleague, you are 61% ANC members. You are sitting in judgment of your political opponents, the EFF. You therefore hold enormous power over your political opponents. And the issue at stake is a political issue. You have obviously framed it, or the prosecutor has framed it, as a breach of the rules. But what is clear is that on the 9th of February 2023, there was a protest by the EFF against its political opponent, the President of the Republic of South Africa. Now, you may disagree with my framing of the issue, but that disagreement is of no moment, because what we argue is that the person who makes a judgment against the EFF must not only be independent, but must also be perceived to be independent. So we ask yourself, we ask you to ask yourself the question, whether any reasonable member of the South African public will perceive a hearing in which the ANC stands in judgment against the EFF as an independent hearing, particularly at the fact-finding stage. Now, this is not the same issue as presenting a bill for voting in Parliament, where majoritarianism applies. And this is not the same issue as deciding whether or not the public protector should be impeached, where again majoritarianism applies. This is an issue whether or not political opponents of the ANC in parliament should be judged by the ANC. And it has severe consequences, not merely among the people that I represent, it has severe consequences among the voters. The effect of the matter is that some people in this country, more than 1 million of them, have chosen the EFF to represent them in parliament. And although when the EFF is here, they are members of parliament, the constitution itself recognizes that they are opposition members of parliament. That is why there is a rule in parliament that there is a leader of the opposition. It is a recognition that they don't lose their political identity when they become members of parliament. So we say that if you continue constituting the committee in the current fashion, you will fall foul of the common law rule against bias, and your proceedings will be unlawful and unconstitutional. So that is why we do not ask that the matter should not sit. We've never made that request. But what we do, we ask that the matter should sit before a neutral, independent chairperson to determine whether or not the political opponents of the ANC are guilty of misconduct. The other consequence of this is that if you look at the penalties that may be imposed in terms of the act, the most drastic penalty is a suspension for a period of 30 days. Now, what that means is that the EFF, particularly its leadership, and I act here for the top leadership of the EFF, you can remove them from parliament for a period of 30 days. And if you were to remove them in parliament on political grounds, and not necessarily on misconduct, because we say that there will always be a stain that you are biased against the EFF because they are your political opponents. But if you remove them for a period of 30 days, what that means is that during that period, any deliberation, and it may even be a State of the Nation address next year in February, or it may be a deliberation on an important bill. But during that period, a significant part of parliament that has been voted into by the public would not be able to participate, which means that this is not about Mr. Malema, but it is about the 1 million or so people that have chosen the EFF to be their representative in parliament. So, argument one, we say that you should remove the stain of perception of bias against yourselves as the members of the ANC. Now, that, of course, does not mean you individually are biased. What it means is that the law regards you on a just perception basis as reasonably biased against the EFF, merely on account of the fact that these are your political opponents. But even if you look at the nature of the charge, it simply strengthens the political bias. This is a charge ostensibly for threatening the president. But this is not just the president of the country, he is also the president of the ANC. You are also members of the ANC, and I accept that you are acting here as parliamentarians. But there is an uneasy feeling that you will protect your own president against the EFF. And that is why you have to remove that perception and appoint an independent person. That person may be a judge, they may be a senior counsel, they may be an attorney. But we cannot see the downside. We cannot see the harm. We cannot see anything that would be harmful to parliamentary autonomy and parliamentary rules if you were to appoint a judge to hear this matter. Section 12 of the Act does not prohibit you from doing so. It does not require you to sit as the disciplinary committee. It merely requires you to ensure that the proceedings are fair and the proceedings are reasonable and the proceedings are rational. And the way to achieve the object of the Act is to appoint a judge to conduct the fact-finding inquiry. So we say, as a matter of the common law, you are obliged to do so. And as a matter of the statute, there is nothing preventing you from appointing a judge to hear this disciplinary hearing. Secondly, are the provisions of the Act itself. I have already explained that those provisions of the Act requires you to ensure that the hearing is procedurally fair and the hearing is reasonable. It is unreasonable, it is procedurally unfair that you should subject the top leadership of the EFF to a disciplinary hearing that is presided over by its own enemy, political opponents. Particularly so because you, as members of parliament, are also witnesses to the incident. You are witnesses to the incident because this happened on the State of the Nation address. You've also made a decision to institute the charges. These charges were not independently instituted, they were instituted by yourselves. You've also made a decision to choose the initiator. And obviously, you've tried to choose the initiator on the grounds that he is independent, which we appreciate. Mr. Katz is an independent man and is a colleague at the bar, and we have a lot of respect for him. That is fine. But what we ask for is that in the same way as you have appointed an independent prosecutor who is truly independent and who is not political, you should also find it in yourselves to appoint an independent judge so that we can debate whether the EFF is guilty or not. There is no benefit to Mr. Katz to sit here and prove a case in front of the same people that are witnesses, same people that have decided to charge the EFF, and same people that will be making the deliberations. So in sum, on this point, you are the judge, prosecutor, and sheriff in one. That is just wrong at so many levels. It's wrong as a matter of constitutional law, it's wrong as a matter of the common law, and it's wrong as a matter of the statute. We have seen the rules that Mr. Katz is permitted to be appointed as a prosecutor, but we say that there is a reason you chose him. You chose him because of his unique characteristic as an independent man, and may I add, also an honorable man. We say you should do the same thing for the appointment of the chairperson. And there is then the third requirement, which is you are bound by Section 1C of the Constitution, and that section requires you to act rationally, and it requires you to act within the scope of your powers. We say the request we've made is within the scope of your powers, but it would also be consistent with the principle of rationality. And if you did not do so, you would be acting irrationally. And it does not mean that you will necessarily find the EFF guilty. You may well find them not guilty. But what you will never remove is the stain that political opponents of the ANC, if they don't please the ANC in parliament, will be subjected to a disciplinary hearing, which ultimately is deleterious to our constitutional order and limits the ability of MPs to be robust when they are inside the precincts of parliament. If the EFF is guilty, as seems to be the view, if Mr. Malema is guilty, let a judge tell him that he is guilty. He will accept that. What is unacceptable is that he should be told by his political opponents who decided that he is guilty, who witnessed that he is guilty, who chose to charge him, and who have a political incentive behind his conviction and the imposition of a penalty against him. So let a judge, let a neutral person, let an advocate, let an attorney make this determination. It is a grave determination, and it should be made independently of yourselves. Now, that, of course, is not to cast an aspersion on you as members of parliament, but it is to state the reality that he cannot expect to have a fair hearing when he is subjected to punishment by his political opponents. So that's the first request. We ask you that you should appoint an independent person, and that person, we say, can be a judge or can be a senior counsel and can be an advocate, an attorney. If you did that, we will be back here in January or February. We will take 3 days or a week. We will finalize this matter, and you will hear no objections from us, at least on the process. and you will get the evidence you want to hear. And if you are confident of your case, you should not fear the subjection of this case before a judge. It is only when you are not confident of the case that you actually want to preserve it for determination by yourselves as politicians. The second application we want to make is a practical matter. This charge sheet was delivered on the 7th of November, and it schedules the matter for the 20th, 21st, and 22nd of November. The charge itself emanated from an incident on the 9th of February, 2023. So which means that for some reason, Parliament has delayed by 10 months. We have not been given any explanation why you have delayed for 10 months. If you thought this matter deserved to be dealt with speedily, expeditiously, and someone says even importantly, we have not been told why you have delayed for 10 months. So you've taken 10 months to constitute a charge on a single incident, one incident. So given that Parliament cannot explain why it has taken them 10 months to prosecute, there can be no urgency in having this application or this disciplinary hearing dealt with today or tomorrow. This is an application that can be dealt with in January or February. There's no reason why it should be dealt with this week. It can be dealt with in January or February. That's number one, is there has been an undue delay by Parliament in instituting these proceedings. And given the undue delay that has not been explained by Parliament, it is grossly unfair and unreasonable that we should now be railroaded, that the matter should be dealt with on such expeditious and speedy grounds. Now, I discussed this with Mr. Katz on Sunday. And then one of the points he made to me was that the rules say you are only entitled to 5 days. Now, that is true. But you must also, as Parliament, act expeditiously if you take these charges seriously. You can't wait for 10 months and then after 10 months, give us 5 days notice. That is just grossly unfair. You should give us enough time to consult, to study the video, to prepare, to raise any points we want to raise, to issue subpoenas, all of those procedural requirements. This is not a Stalingrad application. This is a sensible application to have this application dealt with properly in January or February. If you force us to carry on with a matter that we are not prepared, we are just going to sit here, listen to your evidence, and then thereafter ask for a postponement, because there is no way that we can run this case reasonably within such a short period of time. The second reason is that there is an application against Parliament that is in the High Court on the 4th of December. It has not been brought by this group of EFF MPs. It has been brought by a different group of EFF MPs. But it challenges the validity of the disciplinary proceedings against the EFF arising from a July 2022 incident. But these incidents are related because there is a commonality, which is the persistent view that has been taken by the majority party to prosecute the EFF for what it perceives to be infringements taking place inside Parliament. If that application is decided in favor of the EFF, then your committee will not be able to sit in any event. The current accused, let me say, charged or implicated members, Mr. Malema, Mr. Shivambu, Mr. Ndlozi, Mr. Dlamini, Mr. Pambo, and Mr. Tambo have applied to join that application. And it will be heard on the 4th of December. So it's imminent. It is not as if it will take a long period of time. And one of the points that will be argued before the High Court is precisely this point of the incorrect composition of the committee. Now, the point may or may not be good, but it is irrelevant because the judge is going to make a determination on the 4th of December as to whether or not the committee currently as it sits is properly composed. So we ask you to remove the problem by appointing an independent person. But in any event, the matter is going to be decided by the judge on the 4th of December through interdict proceedings. And then the third point is that there has simply been insufficient time to prepare, and I've already made this point. Once you've taken 10 months to prosecute a case which you claim is a simple case, you cannot say to the accused, you only have a week to prepare. You have to take into account that you've given yourselves 10 months to prepare. Right? Parliament took 10 months to prepare this case. It cannot give the EFF 10 days to prepare. If the Parliament believes that 10 months is reasonable for it to prepare its case, it follows as a matter of logic that it must also give the EFF not 10 months. We ask only for 1 month. We will be back in January. We will be back in February. We can fix a date, fix a time. We're going to run the case. But the truth is that there has been insufficient time to prepare. And the sufficiency of the time can be judged by the fact that you yourselves took 10 months to prepare this case. There is a problem again about the discovery of evidence. That's number 4. One of the charges you make is this idea that there was a threat or intimidation of the president by the EFF. We're going to deal with this in evidence. But we've asked for a subpoena to be issued against the speaker. We will also ask for a subpoena to ask the president whether or not he was threatened, because an allegation of threatening a person is a subjective allegation. It is similar to the provisions of the Intimidation Act of 1982, which has Section 2 of which has recently been declared unconstitutional. But it is a subjective charge. In other words, I cannot say that X has been intimidated or threatened if X says I was never threatened. We know that you don't intend to call the president and you don't intend to call the speaker. But we want to issue the subpoena against the speaker or the president so that they can explain how they have construed the rules, and the president can explain whether or not he was threatened, because you've elected to charge us for threatening the president or storming the stage in a threatening manner. But the stain of the threat is to be felt primarily by the person who is alleged to have been threatened. It is a subjective charge. So whether or not the initiators will be calling the speaker or the president, we will be asking the committee to issue a subpoena against the president, or asking the speaker to issue the subpoena. Now, this is one of the reasons why this must be dealt with independently, because we don't want to place the committee in a position where it must make radical decisions about subpoenaing its own political leaders to appear in a disciplinary hearing. Whereas if this was an independent judge, it would be easy for an independent judge to say, I think witness X is irrelevant. I think witness Y is relevant, and therefore I'm declining your subpoena or I'm granting your subpoena. The problem here is that you have constituted yourselves as a political machine, and that we say is wrong when you are running a disciplinary hearing. So, but we say there is evidence we want to be discovered, including subpoena. But we also want the entire video. The video that we have been shown is very skewed. It shows a portion of the stage, and it is in circumstances where we have to interpret what were the EFF members that went to the stage trying to do. Were they trying to threaten the president, or did they have a different object? Could the president reasonably, on what can be perceived, be threatened? Or is the allegation of threat of the president simply made up in order to bolster an otherwise non-existent case? But those are matters that will be dealt with in due course. For now, what we say is we want a postponement so that we can finalize the question of discovery, so that we can finalize the question of who must be subpoenaed and who must not be subpoenaed. So we say that in those circumstances, it is just impossible I mean, obviously, you can take the political decision to force the hearing. You've got the majority. There's nothing stopping you from doing that. But we say that if you took that view, it would be susceptible to judicial review. The most pragmatic thing is to postpone the hearing for a month, give us until January, or give us until February, and give us a week in January, give us a week in February. We reconvene, we call the witnesses. But in the meantime, it also gives you a chance to deliberate on this idea that we have proposed, that you are in fact under an obligation to ensure that there is independence and a perception of independence. My colleague, Mr. Ramokgale, has prepared written argument on the point I've made about the appointment of an independent panel. We will be submitting those shortly for the consideration by the committee. Thank you. I think I've probably not exceeded my time. I don't know, but thank you, Madam Chair.
Thank you, Advocate. You did not indeed, and I was still going to give you because I want to prove that issue of fairness and biasness. Your 30 minutes were still in, but thanks for the presentation. I will now request the initiator to do the same, to respond.
Thank you, Chair. I must start off by thanking my colleague for the kind comments he's made about me personally, and I share his sentiments that I'm an honourable person with himself. I've known him for a long time, and Mr. Ngwatobi has, in general, always acted in a manner that I would regard as honourable, wise, and intelligent. But having said that, he makes 2 points in his address to the committee, and I'd like to deal with them in the following manner. The first is I'd like to deal with this question of the composition of the committee and explain why, as a matter of law, the point goes nowhere. And thereafter, I will deal with the question of the application for a postponement. We have prepared written submissions on the question of the postponement, which I would like to hand both to the legal team representing the affected members and the committee. It'll immediately be emailed to the committee, and we have hard copies in the chamber to hand out to the legal team for the affected members. But turning to the first aspect, which is the question of the composition of this committee. The composition of the committee is set out in Rule 154 of the Rules of the National Assembly, which is part of Chapter 12. Chapter 12 deals with the committee system, and in clear and unambiguous terms, how this committee is to be composed, and the appointment procedures are set out in Rule 155. Now, unless and until those particular rules have been declared invalid for whatever reason, this committee is entitled to sit in the capacity it sits, which is to give effect to Section 12 and 13 of the Powers, Privileges and Immunities Act of 2004. And before this committee or before the High Court, there is no challenge to the rules in this respect. I know our learned friends suggest that there is, but we haven't seen it, in the sense that there is this composition has been in place for many, many years. This committee has sat, and it would be interesting, and we would submit odd, for the committee itself to find that it itself is unlawfully or improperly composed. And were there to be such a thought, the best way to deal with it is for the committee to get on with its business and make what is called a finding and recommendation, table it in the House, and thereafter let whoever deems it appropriate challenge the validity of the composition, not by way of just this particular composition, but by way of a challenge to the rule itself. That's how these things are done. So even if the committee is persuaded, which I submit it shouldn't be, that there's any merit in this composition point, it's not available for this committee at this point to take any action by, for example, appointing an independent person like the committee or like in respect of my appointment as the initiator. So the point doesn't get off the ground concerning the so-called unlawful composition of the committee. And this committee we would submit can ignore that point in its entirety. Turning to the question of a postponement, I have prepared written submissions, and let me start by saying our learned friend says that today's application for a postponement is, in his view, not Stalingrad. Well, we would disagree. We would submit that today's postponement on its face is Stalingrad on steroids. I will turn to why I say that in dealing with the application for the postponement as was filed on Saturday evening before this committee. There's no merit to the application, and the underlying basis of the application is unfortunately solely lacking in any substance. May I just check with my team whether the heads of argument have been emailed to the committee and given to our learned opponents? So, Chair, I trust that the committee members have now all received soft copies or by way of email of our written submissions. And I would take the committee to it because perhaps in listening to me, it'll be easier and quicker were the committee members to read my submissions as I proceed. In paragraph 1, we deal with the question of the notice to the 6 affected members. In paragraph 2, we deal with the content of those notices. And importantly, Chair and other committee members, what is interesting is that the notices were served on the 6 affected members on a Tuesday night. That following Friday night, or not Tuesday night, Tuesday afternoon, but that following Friday evening at 7:24, the attorneys for the affected members drafted a letter to the Speaker and the Chair, and on the Sunday, the Speaker, through the State Attorney, responded. But it's important to note that on the Friday evening's letter, which was written by Ms. Cupido of Ian Levitt Attorneys on behalf of the 6 affected members, certain points were raised concerning why a postponement should be granted, including the question of the High Court litigation, including the fact that there were, for example, 640 pages contained in the bundle, the hearing bundle. And on the Sunday letter in response, all of these points were taken care of so that, for example, it was explained in paragraph 20 of the State Attorney's letter to Ms. in response to Ms. Cupido that it's all very well saying there's 640 pages in the bundle, but almost all the pages are formal documents such as legislation, the rules of the National Assembly, joint rules, and there was nothing, open quote, new that the 6 affected members would need any time to consider. So the insufficient time on the basis of the bundle is a non-starter. And one sees in paragraph 4 of my submissions that Ms. Cupido's letter requested certain information. There was a request, rather it was framed as a way of a demand that the hearing be postponed to a date in 2024. Again, after judgment by the Western Cape High Court in a matter to be heard on Monday, the 4th of December, 2023. The committee has heard from our learned friend the similar refrain today, and that refrain is included in the application for the postponement that was filed on Saturday evening. And what Ms. Cupido did in her letter was to threaten a High Court interdict to stop these proceedings, prohibit these proceedings commencing. And the response from the State Attorney was, that is inappropriate. It's inappropriate to approach the High Court, rather approach this committee. which is what they did. But the important point that I want to stress is that the 6 affected members knew as long ago as Friday, the 10th of November, that they wanted a postponement. That's 3 days after having been served the notices. And yet they waited 9 days to bring their formal application, the substantive application for postponement, without any proper explanation. And it's a factor that this committee will take into account in deciding whether to grant the postponement. They knew early on, so they would argue, that they didn't have sufficient time, but they waited 36 hours before the hearing, they bring their substantive application. And the courts have replete with authorities which say, if you know you're going to bring a postponement, if it's a good faith application for postponement, do it as soon as you know you want postponement. As soon as you're going to make your application for postponement, make it. But if you wait till the last moment, you're almost hijacking the decision maker to say, well, it's too late. We have to now listen to what they say at the last minute. So we take it further, and if I may turn to paragraph 11, it says there is now a substantive application in which a postponement is sought. And we submit that in paragraph 11, that this postponement application is an abuse. It's a clear stratagem of the 6 affected members to avoid taking responsibility for the alleged disruptive conduct at Sonar. They wish to evade the hearing and the charges at all costs. They were ducking and diving, and such conduct should not be tolerated. And I may just turn away from the note to make this point. Our learned friend has suggested, and we disagree with the suggestion, that the test for the charge of approaching the president and the speaker in a threatening manner is to be determined on a subjective basis. We disagree with him. It doesn't matter what the president, what the speaker, what the 6 affected members thought. It's what the objective facts show happened at the event. So if the 6 affected members had absolutely benign or peaceful intentions into jumping onto the stage in the middle of Sonar, the fact that what was going on through their minds is not an inquiry that this committee will consider. Similarly, what the president thought or what the speaker thought is not of relevance. If the president thought, well, I'm not threatened because I have the VIP protection, I'm not really threatened by 6 people jumping onto the stage while I'm sitting here. Or if the speaker thought similarly, she was at the back end of the stage and she couldn't be threatened because she was quite far from the action. It's irrelevant. So we would submit that it's an objective inquiry, and this committee will draw inferences from the conduct which the 6 affected members were involved in. So the conduct involving the 6 affected members is where this committee will go from an objective perspective. What are the inferences that can be drawn from jumping onto the stage at the time and in the manner that they did so? It's a simple issue. I then turn to the issue of Stalingrad, paragraph 13 of our note. This conduct of delay is classic Stalingrad. The 6 affected members have taken every step, reasonable and unreasonable, just to ensure that the hearing does not commence. On the version testified to by Ms. Cupido on behalf of the 6 members, a postponement is certainly not warranted. So what the committee will do is read and analyze and consider the application by the 6 affected members as testified to by Ms. Cupido. 4 corners of the application are Ms. Cupido's evidence and my learned friends addressed this morning, and make a decision on that. Simply put, we say in paragraph 15, the 6 affected members on their version have not made out a proper case to be granted a postponement. And so we conclude by saying at this part of the heads, there should be no postponement. We turn to give the committee some assistance by how the courts have dealt with applications for postponement. And we start off by in paragraph 18, following the 14 to 17 paragraph. But in paragraph 18, we say in court proceedings, a postponement of a hearing is an indulgence. Let me repeat, it's an indulgence. And in 19, that indulgence will only be granted where the party seeking a postponement demonstrates that it is in the interest of justice to do so. That is the burden of a party seeking a postponement. Now, we accept that this committee is not sitting as a court, tribunal, or arbitration forum. It nevertheless has the power to consider an application for a postponement of a hearing. Let me just stop and say, it is suggested that this committee would find the 6 members guilty or not. That's not true. What the committee does is table a report in the House, and that report will include findings and recommendations. The Act, the Powers Act makes it, and the rules make it clear that the House itself is not bound to follow that report. So this committee plays a recommendatory role rather than a role of making a finding one way or the other. That being so, we make the point that when it comes to the question of a postponement and the court's guidance as to how the committee must consider and exercise its discretion, the criteria, the factors that the courts have set out play what we call an R40 or RI role in how the committee would decide. In other words, to the extent that a court has a discretion, the discretion is far more narrowly tailored and far more narrowly exercised when it comes to the committee itself. So the committee itself will decide, do we grant this party an indulgence? The committee will consider Ms. Cupido's affidavit with our learned friends' oral address this morning and decide with reference to the factors that the courts have set out, but those factors must be given heightened awareness in deciding whether to grant a postponement or not. That point is made in paragraph 22. In paragraph 23, we submit that a proper case must be made out. So there would have to be an explanation. Now, we've heard from our learned friend that the members, they may wish to call the president, call the speaker to hear what's in their mind. That case is not made out anywhere. It's not in the letters addressed by Ms. Cupido. It's not in the affidavit addressed by Ms. Cupido to this court. So one has to look at what is the application that serves before this committee. And the application doesn't talk to any of those types of considerations of who it wishes to call, who the 6 members wish to call, and why. So one would look at the postponement itself. And we say, as far as being given an opportunity to bring a constitutional challenge is concerned, in paragraph 24, the courts have now put their face against the notion that where there is a hearing, whether it be a criminal trial, a labor dismissal hearing, disciplinary hearing of any type, that a party facing the hearing should be entitled first to approach the courts with a constitutional challenge, and thereafter, if they fail, let the hearing go ahead. Courts have said that's not the way to do it. The general way to do it, have your hearing, and if you are not successful in opposing whatever's happening, if you're found guilty, or if you lose the labor case, or if you lose this disciplinary, then at that later stage, you may appeal the ruling, review the ruling, and bring your constitutional challenge. Not upset the whole apple cart by bringing your challenge and then staying the proceedings for a year, for 2 years, for however long, while this constitutional challenge is traveling through the courts. And the Supreme Court of Appeal and the Constitutional Court have said over and over that way of doing things, of staying the proceedings, obtaining postponement after postponement after postponement, is inappropriate. Get on with your hearing, and if you're not successful, then you can bring your challenge. And that's classically the case like this. So, for example, let's assume the 6 affected members have their hearing, and it turns out that the report is one that the report that's tabled in the House is one that they feel comfortable with. They wouldn't bring the constitutional challenge because they would have been vindicated before this very committee. as it is said, perhaps the committee will find that they didn't jump onto the stage in a threatening manner. They didn't disrupt the proceedings as set out in Section 12. Well, then there's no need for the constitutional challenge to be brought. There's no need for all of the, let's call it, interesting constitutional aspects, the composition of the committee to be considered. And they would have been, open quote, not have any black mark or stamp against them. And the million or so voters who have asked those representatives to be part of the House, they would have had their needs properly considered. So we say in paragraph 26, in this case, the committee may, after hearing evidence and considering argument, table the report in Parliament recommending that no action of any kind be taken against these members. And the members may feel that the inquiry conducted was reasonable and procedurally fair, so there would be no need to challenge its report in the House and the procedures adopted by the committee. Now, the point I want to make here is that to predict that the committee will act in an unreasonable and procedurally unfair manner is unfortunate and not warranted by the facts. This committee will act reasonably, will act in a procedurally fair manner, and it's not at this stage for the affected members to second guess how the committee will run its proceedings. We turn to paragraph 27. It's a point that I've already made. This application fits into the premature preemptive category repeatedly warned against by the courts. The postponement application is inter alia on the High Court in constitutional challenge, and then the arguments again are set out in paragraph 29 and 30. Ms. Cupido's arguments for postponement are premised on the potential unfairness and unreasonableness, not the actual unfairness or unreasonableness. And we say if it's potential unfairness or unreasonableness, that in and of itself is no basis to grant a postponement. This committee would then be suggesting, well, they claim they need more time, they claim there's a constitutional challenge, they claim there's 740 million. We as the committee, we don't think we're going to act fairly and reasonably, so we postpone. Doesn't work that way. This committee will do what it is required to do and continue its proceedings until such time as it finalizes the proceedings. And at that point, if the affected members are dissatisfied that they didn't obtain natural justice, fairness, reasonableness from the committee, it is at that point in the future that they may take up these challenges. So in summary, we say in paragraph 32, the members seek a postponement to await the outcome of some High Court case which may have no relevance or any bearing to this hearing. It is emphasized in paragraph 33 that before the House may take any disciplinary action against a member, the committee must, and it's an obligation on this committee, inquire into the matter in accordance with a procedure that is reasonable and procedurally fair. And if it ultimately transpires that the High Court and possibly the Supreme Court of Appeal and Constitutional Court judgments have some bearing on the reasonableness of this hearing and its procedural fairness, the affected members will certainly not be without a remedy. They'd be entitled at that stage in the future to bring whatever challenge they would want to make concerning the so-called irregularity of these proceedings. And just let me say to the committee that even were the High Court challenge to succeed, that's not the end of the matter as far as the hearing or the fairness and reasonableness of this hearing is concerned. Section 172 sub 1 sub B of the Constitution gives the court wide remedial powers to make any order that is just and equitable in the circumstances. And it may well be, and one can't predict, that were the High Court to come to the assistance of the EFF and the Menti and Marais applicants as far as the constitutionality of that which is being challenged, it may, and we would submit probably would, make a ruling that despite the infirmities of the legislation or the rules, the proceedings would not be regarded as unreasonable or unfair. That would be what we would submit would be a serious possibility as to just and equitable remedy that the court might grant. But it's at that stage in the future that the affected members would have the remedies or rights, which whatever they may seek, to challenge these proceedings. But what they try to do effectively is to avoid even having the hearing commence. And when they do that, one has to look at the substance of the application that was brought. And I've made the point over and over, Ms. Cupido's affidavit are the four corners of the evidence that one will consider, that the committee will consider, and they just do not get off the starting point. In paragraph 38, I've made the So, Chair, in paragraph 39...
Chief, I'm calling a point of order.
What is your point of order, Honorable?
His 30 minutes is finished, Chairperson. His 30 minutes is done. He's been addressing here for over 30 minutes. He must be organized.
I think I've had 21 minutes, Chair, according to my clock, but I might be wrong. 21 minutes at this point.
He's not talking to you. There is procedure in Parliament. Keep quiet. He's talking to the chair. Why are you talking? Why are you talking when he's talking to the chair? It's not talking to you. That's the problem of white supremacy. That's the problem of white supremacy.
According
you think you can just disrupt us like that?
According to my watch, he's left with 6 minutes.
You want to allow what? Dlagude, you want to allow what? You want to allow what? We're not Dlagude. You want to allow what?
Honorable Malema, please, can you be orderly, please? I'm chairing. Can you respect the chairperson? You may raise your point of order, I will recognize you, but I'm responding to Honorable Ndlozi's point of order that advocate is left with 6 minutes. Can we allow him to proceed, please?
Yes, Chair.
Proceed, initiate.
Thank you, Chair. In paragraph 39, I was suggesting that the comments of the Constitutional Court in a case called National Police Services Union and others versus the Ministry of Safety and Security and others from 2000 should dominate this court's consideration of the application for postponement. In paragraph 4, the Constitutional Court stated the postponement of a matter set down for hearing on a particular date cannot be claimed as of right. An applicant for postponement seeks an indulgence from the court. In this respect, the applicant for a postponement must show that there is good cause for the postponement. And I'll move on to Myburgh Transport in paragraph 40, 41, Gravenstone versus Neertling, and in numerous other cases to the same effect. In 43, there's the full bench of the Cape High Court where the application was for a postponement in circumstances where the minister in that case, the Minister of Home Affairs, had filed no papers whatsoever in a constitutional challenge to legislation. And the court was put in a difficult position because here it was deciding whether legislation was unconstitutional without any papers from the government. And the court refused a postponement partly because the application for a postponement was brought at such a late stage. So the real question is the late application in this case, together without any merit and substance to the application, we say would suggest that there is no merit. In paragraph 48, I've dealt with the bundle, and I've dealt with the difficulty that the 6 affected members have, is that they complained about the size of the bundle when it was explained in correspondence that the size of the bundle was of no moment because the words are, the documents are all formal in nature, such as the Act and the rules. There's no prejudice of any kind to the 6 affected members with this weighty bundle. There was no response from Ms. Cupido. The insufficient time aspect, which is in paragraph 50, is a non-starter. Our learned friend is quite correct. Item 1 of the schedule to the NA rule states that a notification must be delivered to the member at least 5 working days before the hearing. In the present case, the notice was delivered 8 working days before the hearing. I know that there's a debate whether it was 7 or 8 days, but that's not the point. The real point is it's more than enough time for what is regarded as a single incident. It's 6 members having been asked to leave the National Assembly for good or bad or indifferent reasons, jumping onto the stage in circumstances where the President of the Republic of South Africa and the Speaker of the National Assembly and other presiding officers were present in a particular manner. And there may be evidence to the effect of what objectively the inferences that this committee can draw. So we submit in conclusion, paragraphs 51, 52, and 53. The current application 52 for postponement has been brought for one purpose only: to delay the commencement of the inquiry on unsustainable grounds. It has not been brought in good faith. It has been brought at the 11th hour in what may legitimately be regarded as an ambush. The application for postponement must be dismissed. And we would conclude there, and I hope that I have complied with my 30 minutes. I think I'm on 29 minutes, Chair, but thank you.
Thank you, Initiator. Before I go back to the legal team of the affected member, I would like to check with honorable members whether you do have any clarity questions to the two presentations, both by the legal team of the affected member as well as the initiator. I'm allowing that space now for you, honorable members of the committee. Please assist me by observing hands, our officials, staff members, if there are any. If there is none, it's fine, we'll proceed. And delay, do we have hands?
The Deputy Chief Whip, Chairperson.
Deputy Chief Whip, you are recognized.
Thank you very much, Honorable Chairperson. Good morning to yourself, the initiator, the affected members, legal team, and everyone on the platform. Honorable Chairperson, I want to welcome the presentations made by both sides. But I think it is our responsibility as members of parliament to clarify some of the issues, even though the initiator has already done so. But we really need to emphasize this. Honorable Chair, I won't waste your time, but just to indicate that this committee is not made up of ANC members. There are other parties, namely the ANC, DA, EFF, ATM, and IFP. And the rules of the National Assembly allow any member of parliament to participate in any committee, even if they are not members of those committees. So they allow for that. So any member of parliament is allowed to sit. And again, parliament, like any other institutions that are there, have its own arrangements. We are not a court of law. We are members of parliament. We have our own mechanisms. Our own mechanisms that we use. I think it is proper for us.
There is a point of order.
Oh, okay. My apologies, Chair. My apologies.
Yes, can you allow that point of order?
It would be helpful if you would chair this meeting, because you said you're calling for questions, not some narrative we're being given here. We must not be patronized. We know what this committee is. Why is she giving us a story? You said questions, and you must also stop sleeping there because you called for questions. Please.
It is not night. I'm not sleeping. Let us respect each other, because if I bounce back, you won't like that. Your point of order is sustainable. I was also going to respond to that other members must come up with clarity-seeking question. But thanks, because you alerted me that. But I observed that because the committee will still go and deliberate on that, and you are in order. But don't put any vulgar words which won't allow me to do that to you. So let's respect each other right from day one. Thank you. Honorable Tlakote, honorable member is in order. You are trying to outline, clarify the rules, and the initiator has done so. According to me, as the chairperson, I was requesting clarity-seeking questions. If we don't have, let's leave it in that way, because we will still have time to go and deliberate in the committee. So with due respect, the honorable member is in order. What I don't like is to tell me that I must not sleep. I'm not a child. Thank you. Honorable Tlakode, can you stop there?
Thank you.
And then
Thank you very
we'll
much.
go back to our legal team of our affected members to respond on the response by the initiator. Thank you.
Thank you very much, Honorable Chair. Order taken. Thanks.
Thank you, Chairperson. Let me start. I have 10 minutes, if I'm correct, Madam Chair.
Thank you, Advocate. You are right. You have got 10, but because you managed your time in the first round, I may allow you to add few.
All right.
I want you to be free, because here we're in the hearing, we're listening to each other. That Alderman party pattern is being observed. Thank you, Advocate. You may proceed.
Thank you. Thank you, Chairperson. Let me start then with the first point I tried to make, and maybe I was not clear, and I take responsibility for not being clear. The point I make is that the committee is ANC dominated. According to our calculations, in its current composition, it is 61% ANC. 61%. Decisions have to be taken on 50+1, which means any resolution that has the political patronage of the ANC will be carried through. There's no one who can say anything about that. It's a fact that the ANC dominates this committee at 61%. It's even higher than the National Assembly composition of 57%. The question you have to ask yourself is whether any reasonable person acting reasonably will believe that EFF MPs, including its president and deputy president, that have been subjected to a disciplinary hearing for a political act will receive a fair hearing. That does not mean you yourselves are dishonest, but it means that you are perceived to be politically biased against the EFF, and it is your job to carry out the mandate of the ANC. That is what the judges have said. But where you are going to sit in judgment, that's the point. Where you are sitting in judgment of your political opponents, it is absolutely essential to remove the stigma of bias. Now, I said at the commencement of my address, Madam Chair, that the rule against bias applies. Mr. Katz has not responded to that. He must be taken to accept that the rule against bias applies. Number two, I said at the commencement of my address that you are bound by section 12, subsection 3, subsection A of the Powers and Privileges Act. What that section requires you is that you must inquire into the matter in accordance with a procedure that is reasonable and procedurally fair. So you have a duty to set up a procedure which would be reasonable and procedurally fair. In our view, the procedure that you must set up is the procedure where a judge, a retired judge, conducts an inquiry into the facts and finds out who did what. There is no provision here that you must substitute yourself as a fact finder. Your job is to conduct, in fact, your job is to inquire in accordance with the procedure. So item 1 is develop the procedure. Develop the procedure. And the first item on that procedure is make sure that there is an unbiased judge who's hearing the matter. He can recommend to, he can make findings of fact and recommend to you, and you can vote as you wish. But the fact-finding stage is the procedure that must be presided over by a judge. Now, Madam Chair, you've been here, we've all been here. Mr. Katz has never said that the procedure of appointing a judge will be unlawful. Why? Because he himself knows that a retired judge is a guarantee of independence and fairness. He himself knows that you cannot subject EFF MPs to a political machine of the ANC over a political act. Everybody knows this. You can ram through this, railroad it because you've got the numbers, but it will not substitute the cogency of the legal submission that you have to ensure that the procedure you adopt is reasonable and procedurally fair. Now, that does not mean as a fact you will be biased. It means you are perceived to be biased. And perception of bias is as good as actual bias. Number 3, Mr. Katz says, look at the rules. And then he cites Rule 154, 155. Those are irrelevant rules. You can close your eyes as far as those rules are concerned. The relevant rules are Rule 211, 212, 214. They talk about the composition of the committee. We have no objection to the composition of the committee. We've never said anything about the composition of the committee. Our only issue is who is going to conduct the fact finding? Is it a judge or is it the political opponents of the EFF? Now, when you look, and Mr. Katz says, this committee is not going to make findings whether people are guilty or not. But that means he has not paid attention to Rule 214. Look at Rule 214. It says, 214(2)(b), the committee must table a report in the assembly on its findings, underline findings and recommendations in respect of any alleged contempt of parliament as alleged in section 13 of the Powers and Privilege Act. And then it says, C, if it is found that a member is guilty of contempt or misconduct, the committee must recommend an appropriate penalty from those contained in section 12(5) of the Powers and Privileges Act. So anybody who says that you have no power to make a guilty finding can only say so in ignorance of the rules. We say you should not be ignorant of your own rules. You must know your own rules that you must make the guilty finding. Our submission is the rules do not require you to sit as the disciplinary committee. They empower you to appoint an independent person to make the fact finding so that there is no perception that the ANC is persecuting its political opponents. In other words, it's abusing its majority in parliament. So the debate about the rules is an irrelevant debate, completely irrelevant, because we've never said we want the rules to be struck out. We've never said we want the committee to be differently constituted. What we have said is the rules give you the power to appoint an independent judge in the same way as you've appointed my learned friend who is an independent initiator. Once you have done that, you will take the report of the independent judge, and thereafter you will deliberate and you will vote, and whatever the outcome of that vote is. But what will not happen, you are not going to have Mr. Malema being the subject of interrogation over a so-called misconduct, which is purely political, by his political opponents. That is the argument. And so far, I'm afraid to say there has been no answer to that argument. The only thing that has been done is we have been given the rules. We know the rules, we've read the rules. We could not have come here without having read the rules. We came here because we've read the rules and we have said there is a way in which you can protect yourselves from acting unlawfully by appointing a judge. And nobody has said that the judge is not the correct person to look into whether Mr. Malema committed misconduct or not. And thereafter, you will vote. You still have your majority and you can still decide what you want to do. And that it is wrong to say that there will be no guilty finding. The rules expressly use the word guilty of misconduct. Now, that's item number 1. This idea that we are going to act fairly. We are going to act fairly. If a judge is biased or is perceived to be biased, he or she is removed before the case. The judge is not allowed to run the case. And after having run the case, to say, oh, look at me, I've given you such a fantastic hearing. That is contrary to every rule that exists in the common law, in the Constitution, and elsewhere. The judge is removed at the beginning. We don't ask you to be removed. We ask for something less than that. We say, conduct the fact finding before a judge, take the report, and we will go there. We will defend ourselves. So that's very, very important to understand what the point that is being argued is. In fact, it goes back, I think it was Honorable Hlakude. I heard from that question that maybe it was my fault that I didn't clarify what I was saying. And that is why she's going on a wrong track in assuming that I'm attacking the rules. Instead of saying, I'm asking you to enforce the rules, because the rules require you to act fairly, reasonably, and rationally. And I'm asking you that in order to act fairly, reasonably, and rationally, appoint a judge. And so far, no one has ever said why a judge should not be appointed. There can only be one motivation where a judge is not appointed. It's because certain people want to settle political scores. That can be the only explanation why a judge should not be appointed. We have so far had no explanation whatsoever. So we insist on our initial submission that we ask you with the greatest of respect, get a judge, and Mr. Malema will subject himself to an independent judge. And that does not diminish your standing. That does not diminish the autonomy of parliament. It retains it and it reinforces it. In fact, it even makes it more legitimate that you are prepared to say, let's get a judge, let's get advice, and then let's take it forward. By the way, this is not a radical thing that I'm suggesting. When you are disciplining yourselves, disciplining the public protector, you know the first thing you do? The first thing you do, you get a judge. You had Justice Ngabinde. You had, I think it was Justice Mohoro in the two matters. Even
Advocate, sorry, your time is up, but I'm giving you 3 minutes to wrap up. Thank you.
Yes, all right. So that's on the first issue. Let me leave that. I wanted to make the two examples. Public protector, you've got a judge who makes the first determination and then it goes to parliament. So that's nothing new. Then let me go in the 3 minutes that is left to the issue of postponement. My colleague says, we left it too late. You know, Madam Chair, I don't know if you have this bundle of the postponement application in front of you. If you have it, I will ask you to go to page 39 and 40. We wrote a letter to, not me, but my attorney wrote a letter to Parliament on the 10th of November. And they said, look, can we please get this thing postponed? The state attorney, now that is Mr. Katz's client, instructing attorney, wrote back. At paragraph 7, they said, we point out that it would be premature and an abuse to approach a court without first approaching the Powers and Privileges Committee with whatever complaint your clients may have regarding the notices and charge sheets that were served. So they said they cannot give us an answer. We must come to this committee to request the committee. Now, Madam Chair, listen to this. When we come to the committee, they say we came to the committee too late. They themselves said they couldn't give us an answer. The state attorney said, I can't give you an answer, go to the committee. Today we are in front of the committee. What are we being told? We are being told we came too late. So there is a fundamental inconsistency that is being played by the state attorney side. Then the last point to be made goes into the issue of Stalingrad. I have never seen a case where an application is made for the first time and where there is a commitment to hear the case in a month. I've never seen that case being reduced into Stalingrad. It's the first time. And so you have to be careful not to be hoodwinked by fancy terms, Stalingrad. It applies to Mr. Zuma's case, the judges have found. It doesn't apply to Mr. Malema's case. And Stalingrad applies in criminal cases and it doesn't apply in parliamentary proceedings. This is the first application, and we have said we are going to be back in January. We need about a month to prepare. And then somebody jumps Stalingrad. You have to be taken seriously in your job as parliamentary MPs. So, in summary, we say, appoint a judge, we will appear. Number 2, we say, give us time. We need about a month to consider this. The submissions have been circulated, I'm told, for the benefit of the committee. Thank you, Madam Chair. I hope I have stayed within the extra 3 minutes.
Thank you, Advocate. Indeed, we have done so. Thank you so much. Honorable members, our initiator, the legal team of the affected members, thank you so much. I want to now inform the August House that I'm intending that we suspend the proceedings of the hearing in order for the members of the committee to meet as a committee. We'll suspend it for 1 hour and then we'll resume again today. So the difference here features is that the meeting of the committee is that only members of the committee will participate in the deliberations about the matter presented before us. The affected members, their legal team, and the initiator will not participate in the deliberations of the committee. So the hearing is now suspended. Thank you.
Thank you, Chair.
Thank you.
Chair.
Recording stopped.
Hello. Yes, Honorable, you are noted.
Chairperson, before I come into the question as proposed, just for records purposes and procedure, if we could have a confirmation that because we are using the same link, if we could just have a confirmation that we are now assembled correctly as the committee. Just confirmation, and then we continue
You
for
are
record
right.
purposes.
Can our staff members confirm that? I have checked, but I might not be clear about whether those are on the platform are the relevant members for the portfolio committee as rolled by the chair. Can you confirm that, Andile, for us? Mkolis.
Yes, Chair, the meeting has a quorum, Chair, so that it can proceed.
Again, are the only members of the committee which are here as rolled by the chair in the previous hearing?
Another thing, Chair, we have
Yeah,
M46. We don't know who is M46.
Yeah, that's
Chair,
why I'm saying let
we
them
have-
assist us. Yes.
We have only members of the committee on the platform, and Chair, M46 is it's not a person, Chair. It's just the link.
Come again.
Chair, M46 is just a venue for connecting. It's not a person.
Okay, it's not a link. I get
Chairperson?
you. Yes.
Chairperson, sorry, this is Honorable Lottery. I am concerned because on the participants list, it says M46 and there is a video, so the link is live. Is what we saying now audible in M46?
Yeah, that's what members want to be sure about this. Can we be assisted by our staff members there? That's
Yes,
why my request was to have a new link as the committee for this for this 1 hour, and then we go back to the hearing if it is possible to the previous link. Can we do that?
At the venue, there's only the staff, the procedural staff that supports the committee. The legal teams have gone out. So on the platform, it's only the members of the committee who are on the platform. The affected members are not on the platform, Chair.
But the honorable member who has just spoken, her concern is that this venue is connected, is live. So that's what she was saying. Can you assist us on that one so that we can be able to start? Because I want to guarantee members and to be at the same page, all of us.
Chair.
Honorable Lodrick, are you answered?
Public meeting. Remember, Chair, this is a public, it's not a private meeting. The default positions in terms of our rule, meetings of the committees are public. So the meeting has to be broadcast. It's open to public. Members of the public who wants to sit here and follow proceedings, they can do so.
Okay. I'm sure everyone is now answered. We'll proceed. As I have indicated, can we deal now with the input, whether we grant or not grant, state reason, whether we do grant the application or we do not grant the application. The floor is open for your input, honorable members. I believe all of us were now answered.
Dr. Lottery's hand is up. Ms. Majosi's hand is up. Deputy Chief Whip of the Majority Party's hand is up, Chairperson, in that order.
Thank you, Dr. Ludwig. The stage is yours.
Thank you, Chairperson. Chairperson, in terms of the postponement application, I am of the opinion that it should not be granted. I think everything has been set down. The initiators have been prepared. They have, they know exactly what to do. I am quite sure that the affected members' legal team also has access to all the information. So from my side, I would not support a postponement. We have the fact that it's the end of the term almost, and I'm sure it will be difficult to get the legal teams with specific dates again. They are available now for this week. Thank you.
Thank you, Dr. Honorable Majos.
Thank you, Chairperson. Let me greet the chair and all honorable members. I think I will also fall on the previous speaker. Why? Because the argument that they are bringing, it says, Chair, that they are willing to come to the committee when we appoint an independent judge. And they are telling us about our own rules, which does not accommodate that. So by the look of things, whether we postpone or not, which means they are not going to come and appear into the committee without that independent judge. I might not be privy to the previous discussions and the previous meeting, but I got the presentation from the advocate that is arguing. And Chairperson, I think because we have given them enough time and all documents were sent and everything that they needed all in due time. And they came here because they were supposed to appear to the committee, not because of they would want the committee to postpone due to the fact that we must appoint an independent judge and make references to the public protector and all sorts of other institutes. We are not speaking of institutes that are entities of government, but we are here as the Committee of Powers and Privileges and dealing with members of the parliament. We're not dealing with extended members who are appointed maybe or so forth. We are all dealing with members of parliament. So I don't think it's correct, Chair, that we must postpone. It must the hearing must continue. And if this is our fourth term, the previous speaker has said, and we are only closing now. If they want a month, which means it's going to be 2 months, which means we must come back in January, and we must now still go back and argue the fact that we must have an independent judge, of which I don't believe that we should do that, and we must be mandated by an advocate that that is what we must do as members of parliament. We know our rules, we have followed them, and I think we must follow suit and make sure that this hearing sits. Thanks, Chair.
Thank you, Honorable Majos. Honorable Zakode.
Thank you very much, Honorable Chairperson. Good afternoon, honorable members. Listening to both presentations by the initiator and the affected members' legal reps. Honorable Chairperson, one came to the conclusion that this is indeed, as the initiator has said, it's a parliamentary process. We are governed by our rules. We have a responsibility to sit in this committee and deal with our own internal arrangements. So, Honorable Chair, I want to agree with my colleagues who have spoken before me that the issue of hiring or getting an independent judge to run this process doesn't arise anyway. because this is a parliamentary process. It is not for the first time that the Powers and Privileges Committee have to sit and deal with matters like this. We've been dealing with that ever since this Powers and Privileges Act was adopted. So we will proceed with the work that is before us. The issue of an outsider chairing a parliamentary committee meeting is neither here nor there. They are entitled to their views, of which we are not going to say they shouldn't say what they believe is what should happen. So, but us as Parliament, we have a responsibility according to the rules and also according to the Powers and Privileges Act that we must be composed and as a committee deal with whatever is referred to us as a committee. Like I said earlier, that Rule 185 of the National Assembly rules allows for any member of parliament to sit in any committee and participate, except for when it comes to voting. Those members cannot vote, but participating, they are allowed to do so. So, Honorable Chair, I just want to say this application for postponement is not accepted, as the other honorable members have said, and also we cannot usurp our responsibility as a committee to other people. So this is our work, we'll do it. Thank you.
Thank
Chair,
you, Honorable.
other members that have hands.
Yes, can we recognize them?
Dr. Klape and Mr. Kaba.
Dr. Tlape, Honorable Dr. Tlape.
Thank you, Chair, and greetings to the members of the committee. Chair, I support the honorable members that spoke before me, and I'm also taking my submission from the arguments that has been made before this committee this morning, particularly from the initiator, Chair. One is that the postponement has no relevance. If we have to develop a process, it's for this committee to say the process will be undertaken by this committee according to the rules that it has, or that it will have been set by the committee or has been set for the committee. I must also, Chair, register my displeasure for the affected members or their representative to wanting to reduce a committee of parliament to members of the ANC. That should be not allowed or tolerated. And like the initiator has said, even the court sitting that they're arguing that is sitting on the 4th of December has got no issues with this. Court has always said to go through your hearing process. If you're having challenges or you are not satisfied, you can then approach the courts. So there's no relevance in terms of postponement, Madam Chair. Thank you.
Thank you, Dr. Tlape. Honorable Kaba.
Yeah, thank you, Chair. I think also, Chair, in welcoming as the presentation is done, also from the initiator, let me join other members to also say that the application should not be allowed. The hearing must indeed continue. And I join other members to also, Chair, to say the behavior and the mistreatment that was done to you really is not welcome. I think we remain shut to respect the proceedings. However, it is important that we support you, Chair, and we respect your authority. For other members who may have misbehaved in any other manner, I would employ on you, Chair, to really be hard where necessary rules of Parliament applies. Chair, no postponement. The hearing must continue. Thank you.
Thank you, honorable members. Do you still have any other hands?
No, Chair. Those were the only hands.
My hand is up. Desiree van der Walt.
Honorable van der Walt.
Van der Walt.
Chair, I don't want to be repetitive, but I fully support the proposal by Dr. Lotriet. I think if one applies one's mind and you read the documents and listen very carefully, that is the way to go. And I would also just like to add to say that the tone of people during the previous part of the meeting is unacceptable for members of parliament, and especially to you as the chair and as well as to the initiator. Thank you, Chair.
Thank you. Thank you, honorable member. Any other hand? No other hands.
All, Chair.
If there are no any other hands, the majority view is that no postponement should be granted. So that's the decision of the committee. And then we'll, we are not suspending this one. We're closing this committee meeting, and we'll go back and resume our hearing and pronounce ourselves properly, the decision of the committee that there is no postponement which is being granted based on the facts which members has alluded, as well as the presentation and the response by the initiator. Thank you, honorable members. The meeting stands adjourned.
Yeah, just a reminder that the meeting will resume at 12:30. You had indicated that the hearing will resume at 12:30. You had indicated that the break is for an hour. Thank you, Chair.
Thank you. Yeah, let us have an early lunch,
Using the
honorable
same link.
members.
Yeah.
12:30, we go back to the very same link. Thank you.
Recording stopped.
Thanks, Chair.
Thank you, Chair.
carefully read and considered the application for a postponement of the hearing. The committee has also taken into account their legal representatives' argument in favor of the grant of a postponement. The committee has also considered the written and oral submissions advanced by the initiator. The essence of the complaint in the postponement application is that for the hearing to commence on the 20th of November 2023 will be unfair to the affected members. The committee has an obligation to conduct itself constitutionally and to act reasonable and in a procedural fair manner at all times. That is a requirement contained in inter section 12 subsection 3b of the powers, privilege and immunities of Parliament and the Provincial Legislatures Act 4 of 1994. This provision requires the committee to inquire into alleged conduct of contempt of Parliament in a manner that is reasonable and procedural fair. A person who applies for a postponement seeks for an indulgence. He must make out a case for the postponement. If the affected members are dissatisfied with the manner in which the inquiry is conducted by the committee, they may take whatever steps they deem appropriate after the committee has tabled its report and findings to the House, and after the House has made its ruling. Taking all relevant factors into account, the committee has not been persuaded that the inquiry will not be conducted in a reasonable and procedural fair manner. The affected members have not made out a case for a postponement of their hearing. In the circumstances, the committee has decided that there is no factual or legal basis for the hearing to be postponed, and the inquiry should commence. No application for a postponement is refused. That's the decision of the committee and the ruling by the chairperson. I thank you. I will now call upon the initiator to put the charges to the affected members.
Chair.
Yes, Honorable Ndozi.
It's Honorable Malema.
Oh, Honorable Malema, sorry. Over to you,
Thank you very
Honorable.
much. We heard your response, and we don't agree with it because we believe that in every situation like the one we are faced with now, there will never be a refusal to grant a first request of postponement. It's very clear that we are being subjected to a kangaroo court, and which we're not going to accept. And you brought this white man here to come and persecute us because you know that every white man will go after the blood of the EFF. That's what he's there for. I don't care whether my legal representative says he's got respect for him. I've got no respect for him. He's a DA lawyer. He's a well-known DA lawyer who's here
Honorable
looking
Malema,
for
Honorable
our blood.
Malema, can you make your point?
And we're not
rather
going
than
to accept that. I'm making a
I'm
point. You
request-
can't tell me how to speak. I'm making a point.
I'm requesting you not to be personal.
I'm
Respond
personal.
to the
You can't tell me what to say. You can't tell me what to say. Let me make my point, and then you can rule me out if you want. So all I'm saying is you brought an apartheid apologist and beneficiary to come and persecute me. No white man can persecute me. I'm not going to allow that. And no white man will persecute the EFF. And we're not going to accept to appear before this white man and before this kangaroo court. You can go and be together in your own arrangement there. We are not going to participate in this kangaroo court because its outcome has been determined even before by yourself and the DA. That's why you brought a DA lawyer here to come and speak to us. He's not a man of integrity. He has got no integrity to can persecute us and will never be persecuted by a white man. We refuse to appear before a white man. We refuse to appear before a kangaroo court. Do what you want to do. Some of you won't come back to this parliament, especially you, Chairperson, and many of you. You are going to watch parliament from home. Whatever decision you take will still be in that parliament, whether that white man you called likes it or not, we will be in parliament. As a result, we recuse our legal representatives. They must now leave that place, and we're also leaving this nonsense of a kangaroo court. Thank you.
Thank you, Honorable Malema. That's your view. Myself, as the chairperson, I don't care whether I come back or not, but I'm chairing this session. I'm proceeding with the hearing. My ruling has been, the decision of the committee is that we refuse the postponement and we are proceeding. I will now call upon the initiator to proceed as requested, to put the charges to the affected members.
And my learned friend has asked me for an opportunity to address the committee, and I have no objection to my learned friend doing so.
Thank you. I know, Madam Chair, that you're quite keen for the charges to be placed. I'm sure that will happen in a moment. I just want to note two aspects on the legal side. Mr. Malema has addressed the politics of the matter. The first one is we would like the transcript of the deliberations. Someone told me that they had listened to the deliberations. I think they were available on YouTube. There is a disjuncture between the deliberations and the ruling that has been given. So we would like to scrutinize that quite carefully. So we would like the raw data of what was discussed, because it doesn't seem to tie up with what has been delivered. That's number one. And then number two, we just note that we also asked for a ruling on the appointment of a judge. There has been neither deliberation nor decision on that issue, but both of those matters, we would like to take them up in the Western Cape High Court. But at this point in time, we would simply like the actual transcript of the deliberation. You have also heard that my client has excused me from the hearing, but I have to give due deference to the committee to indicate that in the absence of a client, I have no mandate to remain. My juniors also have no mandate, and my attorneys have no mandate. So if I pack my bags, it's because my client has instructed me to excuse myself. But I still need to get the final word from yourself that I can pack my bags.
Advocate Toby, you are leading the affected members. I don't think that I've got powers to can instruct you to do that. It's your right with your affected members to take a decision. The ruling made by the chairperson is the deliberation and the decision of the committee. I'm not a committee member alone, so I won't evenly say that go or do not go. My surprise is that you are leading them and you are representing them, but the decision have been done by the affected members rather than yourself. So I don't have any obligation to can say you stay or you do not stay. The ruling of the committee still stands. We are proceeding. Thank you.
Yes, Madam Chair, I understand that, but the point is that I don't want tomorrow that there is an issue that I acted in contempt of the Parliament or the committee. So that's the only point I'm making there, to say, look, you've heard my instructions, and but if you say you are neutral on the subject, then there's no problem.
I'm now addressing the hearing. As I've indicated that the ruling has been made and still stands, I'm proceeding. I'm now requesting the initiator to put the charges to the affected members.
Thank you, Chair. I'm not sure, but I think our learned friends are intending to vacate the hall at this point, and perhaps they should just be given an opportunity to do so, as I understand it.
Yes, I may. Yes, you are right. Let's allow that process to unfold. Thank you.
Thank you.
Thank you, Chair. And I note that the legal representatives of the affected members have all left the chamber, and it is for me to now put the charges to the 6 affected members. But in doing so, perhaps I should preface what I'm about to do with just pointing out that item 7 of the schedule, which deals with the procedures for this committee, Schedule 7 to the rules, gives members the right to be present. It doesn't oblige them to be present. And because they were given that right and have chosen, they've made an election to leave for the reasons they've articulated, I just wish to refer to one case, but the issue is not difficult to understand, but it's one case from the Labour Court in Johannesburg of November 2021. And the name of the case is Futshane, F-U-T-S-H-A-N-E versus Millard, N-O and others, square bracket 2021, square bracket ZALC JHB 432, 3 November 2021. And in paragraph 24, the point is made in a labor context that once an employer institutes disciplinary action and gives the affected employee notice thereof, it is open to the employee to attend or to refuse to attend the inquiry. Should the employee refuse to attend the inquiry, such employee must be prepared to accept the consequences thereof, one of which is that the inquiry will proceed in his absence and adverse findings may be made. And that principle is not one which has not been accepted throughout South Africa, whether it comes to labor, disciplinary matters, or any other type of admin action. If a person has a right to attend, they choose not to exercise that right, they take the consequences, whatever they may be, of exercising that choice. So now I turn to the charges, and the committee will know that because the affected members are not present, the chairperson may or must I'm told, Chairperson, that one of the 6 affected members is still on the platform, and the question that has been put to me by the parliamentary advisors is that they're not sure that's proper for one of the affected members to remain on the platform in circumstances when they've taken a decision to not be present during the hearings for the reasons that they've articulated. So perhaps, Chairperson, I would ask for a ruling on that issue.
Thank you, Initiator. Can the member be removed from the platform, please?
Yeah. Yes, apparently that member has been removed. And I now turn to the charges. The first charge that I wish to put is to, and perhaps I should just go in the order in which the notices of hearing have been dealt with. And the first charge is to that of Honourable Member Malema. And I'm going to read the preamble to the charges, and then I will ask that the chair make, as she is required to do, a plea of not guilty into the record on behalf of each of the members after I've read the 6 charges in respect of each of the 6 affected members. So the preamble starts off, I just want to make sure that I do it in the correct order, to Honourable Member Malema. Preamble to the charges. On 9 February 2023, there was a joint sitting of Parliament where the business of the day was the State of the Nation address, sonar by the President of the Republic of South Africa in terms of order paper JS 2-2023, the joint sitting. It is a significant national event and was attended by members of Parliament, foreign dignitaries, and the head of the judiciary. It was viewed through mainstream media and social media by millions of people in South Africa and the international community. During the joint sitting, you, as well as Mr. Shivambu, Mr. Pambo, Mr. Dlamini, Dr. Nodlozi, and Mr. Tambo ascended onto the stage without the authority to do so and advanced towards the President of the Republic of South Africa, the President, and the presiding officers in a threatening manner. Your conduct, as particularized above, resulted in a suspension of the proceedings and your removal from the House by the Security Services of the Republic of South Africa. Charge 1, contempt of Parliament. It is alleged that you are guilty of contempt of Parliament in terms of section 13A and C, read with section 7A and E of the Powers and Privileges and Immunities Act of Parliament and Provincial Legislatures Act 4 of 2004, and the National Assembly Rule 654A and D, Rule 69A and F, in that as a Member of Parliament and during a joint sitting of the Houses of Parliament on 9 February 2023 at City Hall, a precinct of Parliament in terms of section 2(1)D of the Act, where the business of the day was the State of the Nation addressed by the President of the Republic of South Africa, you deliberately created and took part in a serious disturbance, disorder, and disruption in the House, and acted in a way which was seriously detrimental to the dignity, decorum, and orderly procedure of the House by 1, acting with Mr. Shivambu, Mr. Pambo, Mr. Dlamini, Dr. Nodlozi, and Mr. Tambo. You ascended onto the stage without the authority to do so, and in a threatening manner approached the President of the Republic of South Africa and the presiding officers, and had to be physically removed by security services of the Republic of South Africa, resulting in a suspension of proceedings. Those are the charges to Mr. Malema, Chair. And your job, as we understand it, Chair, is to put in place of the explanation or plea by the affected member a plea of not guilty. And I'll ask, Chair, that you register and record a plea of not guilty on behalf of Mr. Malema, Honourable Member Malema. Chair?
Yeah, thank you. I'm registering that on behalf of Honorable Malema, a plea of not guilty. Thank you.
Thank you. I now turn to the second person to be charged, and I'm going to refer the charges in respect of Dr. Nodlozi, and that reads similarly to the charges against Honourable Member Malema. And I'll start off with a preamble to the charges. On 9 February 2023, there was a joint sitting of Parliament where the business of the day was the State of the Union address, sonar, by the President of the Republic of South Africa in terms of order paper JS 2-2023, the joint sitting. It is a significant national event and was attended by members of Parliament, foreign dignitaries, and the head of the judiciary. It was viewed through mainstream media and social media by millions of people in South Africa and the international community. During the joint sitting, you, as well as Mr. Malema, Mr. Shivambu, Mr. Pambo, Mr. Dlamini, and Mr. Tambo ascended onto the stage without the authority to do so and advanced towards the President of the Republic of South Africa and the presiding officers in a threatening manner. Your conduct, as particularized above, resulted in a suspension of the proceedings and your removal from the House by the Security Services of the Republic of South Africa. Charge 1, contempt of Parliament. It is alleged that you are guilty of contempt of Parliament in terms of section 13A and C, read with section 7A and E of the Powers, Privileges, and Immunities of Parliament and Provincial Legislatures Act 4 of 2004 and National Assembly Rule 64A and D, Rule 69A and F, in that as a member of Parliament and during a joint sitting of the Houses of Parliament on 9 February 2023 at City Hall, a precinct of Parliament in terms of Section 2(1)D of the Act, where the business of the day was the State of the Nation addressed by the President of the Republic of South Africa, you deliberately created and took part in a serious disturbance, disorder, and disruption in the House, and acted in a way which was seriously detrimental to the dignity, decorum, and orderly procedure of the House by acting together with Mr. Julius Malema, Mr. Mr. Nico Floyd Shivambu, Mr. Pambo, Mr. Dlamini, and Mr. Tambo. You ascended onto the stage without the authority to do so, and in a threatening manner approached the President of the Republic of South Africa and the presiding officers, and had to be physically removed by security services of the Republic of South Africa, resulting in a suspension of proceedings. Chair, those are the charges put to Dr. Ndlozi.
Thank you. I now present on his behalf a plea of not guilty. Thank you.
Thank you, Chair. I now turn to Mr. Shivambu. Preamble to the charges. On 9 February 2023, there was a joint sitting of Parliament where the business of the day was the State of the Nation address, SONAR, by the President of the Republic of South Africa in terms of Order Paper JS 2-2023, the joint sitting. It is a significant national event and was attended by members of Parliament, foreign dignitaries, and the head of the judiciary. It was viewed through mainstream media and social media by millions of people in South Africa and the international community. During the joint sitting, you, as well as Mr. Malema, Mr. Pambo, Mr. Dlamini, Dr. Ndlozi, and Mr. Tambo ascended onto the stage without the authority to do so and advanced towards the President of the Republic of South Africa and the presiding officers in a threatening manner. Your conduct, as particularized above, resulted in a suspension of the proceedings and your removal from the House by the security services of the Republic of South Africa. Charge 1, contempt of Parliament. It is alleged that you're guilty of contempt of Parliament in terms of Section 13A and C, read with Section 7A and E of the Powers, Privileges, and Immunities of Parliament and Provincial Legislators Act 4 of 2004, and the National Assembly Rule 64A and D, Rule 69A and F, in that as a member of Parliament and during a joint sitting of the Houses of Parliament on 9 February 2023 at City Hall, a precinct of Parliament in terms of Section 2(1)D of the Act, where the business of the day was the State of the Nation addressed by the President of the Republic of South Africa, you deliberately created and took part in a serious disturbance, disorder, and disruption in the House, and acted in a way which was seriously detrimental to dignity, decorum, and orderly procedure of the House by acting together with Mr. Malema, Mr. Pambo, Mr. Dlamini, Dr. Ndlozi, and Mr. Tambo. You ascended onto the stage without the authority to do so, and in a threatening manner approached the President of the Republic of South Africa and the presiding officers and had to be physically removed by security services of the Republic of South Africa, resulting in a suspension of the proceedings. Those are the charges put to Mr. Shivambu, Chair.
Thank you so much. On his behalf, I enter a plea of not guilty. Thank you.
Chair, I turn to the charges to be put to Mr. Tambo. I'll read the preamble. On 9 February 2023, there was a joint sitting of Parliament where the business of the day was the State of the Nation address, SONAR, by the President of the Republic of South Africa in terms of Order Paper JS 2-2023, the joint sitting. It is a significant national event and was attended by members of Parliament, foreign dignitaries, and the head of the judiciary. It was viewed through mainstream media and social media by millions of people in South Africa and the international community. During the joint sitting, you, as well as Mr. Malema, Mr. Shivambu, Mr. Pambo, Mr. Dlamini, Dr. Ndlozi ascended onto the stage without the authority to do so and advanced towards the President of the Republic of South Africa and the presiding officers in a threatening manner. Your conduct as particularized above resulted in a suspension of the proceedings and your removal from the House by the Security Services of the Republic of South Africa. Charge 1, contempt of Parliament. It is alleged that you're guilty of contempt of Parliament in terms of section 13A and C, read with section 7A and E of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act 4 of 2004, and National Assembly Rule 64A and D, Rule 69A and F, in that, as a member of Parliament and during a joint sitting of the Houses of Parliament on 9 February 2023 at City Hall, a precinct of Parliament in terms of section 2(1)D of the Act, where the business of the day was the State of the Nation address by the President of the Republic of South Africa, you deliberately created and took part in a serious disturbance, disorder, and disruption in the House, and acted in a way which was seriously detrimental to the dignity, decorum, and orderly procedure of the House by acting together with Mr. Malema, Mr. Shivambu, Mr. Pambo, Mr. Dlamini, and Dr. Ndlozi. You ascended onto the stage without the authority to do so and in a threatening manner approached the President of the Republic of South Africa and the presiding officers and had to be physically removed by security services of the Republic of South Africa, resulting in a suspension of proceedings. Chair.
Thank you. Thank you so much. And now enter a plea of not guilty on his behalf. Thank you.
Thank you, Chair. I'm turning to the fourth person to be charged. That's Mr. Pambo. And again, I read the preamble to the charges. On 9 February 2023, there was a joint sitting of Parliament where the business of the day was the State of the Nation address by the President of the Republic of South Africa in terms of order paper JS2-2023, the joint sitting. It is a significant national event and was attended by members of Parliament, foreign dignitaries, and the head of the judiciary. It was viewed through the mainstream media and social media by millions of people in South Africa and the international community. During the joint sitting, you, as well as Mr. Malema, Mr. Shivambu, Mr. Dlamini, Dr. Ndlozi, and Mr. Tambo ascended onto the stage without the authority to do so and advanced towards the President of the Republic of South Africa and the presiding officers in a threatening manner. Your conduct as particularized above resulted in a suspension of the proceedings and your removal from the House by the Security Services of the Republic of South Africa. Charge 1, contempt of Parliament. It is alleged that you are guilty of contempt of Parliament in terms of section 13A and C, read with section 7A and E of the Powers, Privileges, and Immunities of Parliament and Provincial Legislatures Act 4 of 2004 and National Assembly Rule 64A and D and Rule 69A and F. In that, as a member of Parliament and during a joint sitting of the Houses of Parliament on 9 February 2023 at City Hall, a precinct of Parliament in terms of section 2(1)D of the Act, where the business of the day was the State of the Nation address by the President of the Republic of South Africa, you deliberately created and took part in a serious disturbance, disorder, and disruption in the House and acted in a way which was seriously detrimental to the dignity, decorum, and orderly procedure of the House by acting together with Mr. Malema, Mr. Shivambu, Mr. Dlamini, Dr. Ndlozi, and Mr. Tambo. You ascended onto the stage without the authority to do so and in a threatening manner approached the President of the Republic of South Africa and the presiding officers and had to be physically removed by security services of the Republic of South Africa, resulting in a suspension of proceedings. Yes, Chair, that was the fifth person to be charged, and it's now called upon you to enter a plea for that person.
Thank you. I must enter a plea of not guilty on his behalf. Thank you.
And I turn to the last person to be charged, Mr. Dlamini. Again, the preamble to the charges on 9 February 2023, there was a joint sitting of Parliament where the business of the day was the State of the Nation address by the President of the Republic of South Africa in terms of order paper JS2-2023, 23, the joint sitting. It is a significant national event and was attended by members of parliament, foreign dignitaries, and the head of the judiciary. It was viewed through mainstream media and social media by millions of people in South Africa and the international community. During the joint sitting, you, as well as Mr. Malema, Mr. Shivambu, Mr. Pambo, Dr. Nodlozi, and Mr. Tambo ascended onto the stage without the authority to do so and advanced towards the President of the Republic of South Africa and the presiding officers in a threatening manner. Your conduct, as particularized above, resulted in a suspension of the proceedings and your removal from the House by the security services of the Republic of South Africa. Charge 1, contempt of Parliament. It is alleged that you are guilty of contempt of Parliament in terms of Section 13A and C, read with Section 7A and E of the Powers, Privileges and Immunities of Parliament and Provincial Legislators Act 4 of 2004 and National Assembly Rule 64A and D. Rule 69A and F, in that as a member of Parliament and during a joint sitting of the Houses of Parliament on 9 February 2023 at City Hall, a precinct of Parliament in terms of Section 21D of the Act, where the business of the day was the State of the Nation addressed by the President of the Republic of South Africa, you deliberately created and took part in a serious disturbance, disorder, and disruption in the House and acted in a way which was seriously detrimental to the dignity, decorum, and orderly procedure of the House by acting together with Mr. Malema, Mr. Shivambu, Mr. Pambo, Dr. Nodlozi, and Mr. Tambo. You ascended onto the stage without the authority to do so and in a threatening manner approached the President of the Republic of South Africa and the presiding officers and had to be physically removed by security services of the Republic of South Africa, resulting in a suspension of the proceedings. Chair, that's the last charge that I put to one of the affected members.
Thank you. I now enter a plea of not guilty on his behalf, on behalf of Honorable Shaman. Thank you.
Thank you, Chair. Chair, with your permission, I would be inclined now, and I propose to call a witness on behalf of the initiator. The person is Mr. Klaxo, who is the Secretary to the National Assembly. With your permission, Chair, I ask that he be sworn in so that he may give his evidence concerning the charges put to the 6 affected members. Thank you, Chair.
Thank you. Rule 168 requires that before a witness gives evidence before a House or committee, the chairperson must, in accordance with Section 16 of the Powers and Privileges Act, inform the witness as follows. Open quote. Please be informed that by law you are required to answer fully and satisfactorily all the questions lawfully to you, or to produce any document that you are required to produce in connection with the subject matter of the inquiry, notwithstanding that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. You are, however, there is noise. IT, can you assist us? There are some background which are not fine. Thank you. You are, however, protected in that evidence given under oath or affirmation before a House or committee may not be used against you in any court or place outside of Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. So, based on this provision of Rule 169, I now checking with our witness whether he has got any objection to take any oath or making an affirmation.
The person, I have no objection to taking the oath.
Can you raise your right hand and say this after me? I swear that the the testimony or evidence I'm going to give is the truth.
I swear that the testimony or evidence I'm going to give is the truth
And only the truth.
and only the truth.
So help me God.
So help me God.
I confirm that the testimony or evidence I'm going to give to this, the truth and only the truth, and binding on my conscience. I'm now recognizing the initiator, Advocate Kasi, who will present the evidence regarding the allegations.
Thank you. Thank you, Chair. Mr. Klaasel, could you explain to the committee your employment position in Parliament? And when you do so, if you could explain somewhat of your history within the precincts of Parliament and your employment history. In other words, your CV and how you find yourself in employment today.
Chairperson, I am Secretary to the National Assembly. I have been in this position since 2013. However, I've been employed in Parliament since 1994, and I started as a committee clerk at the time, and I spent about 6 years in that role and a senior role, relatively senior role there. And in 2002, I joined House proceedings or the National Assembly to deal with House proceedings. In 2004 or 2005, I was appointed as Undersecretary for House proceedings or House plenaries. And in 2013, as I indicated, I then became Secretary to the National Assembly. So this year was my 10th year in this role. In terms of education, I have qualifications in law and public administration. That is me, sir. Thank you.
And what are your functions as the Secretary to the National Assembly, and particularly with reference to a joint sitting at which the State of the Nation address is to be delivered?
The Secretary to the National Assembly is the chief advisor, if I may say, on matters of parliamentary law/procedure. So the role that I would play in relation to a joint sitting or a house of the assembly would be that of giving advice on the rules of parliament. In a joint sitting, of course, joint rules. But generally to ensure that the proceedings of the House are run in accordance with the rules, with the Constitution, and any applicable law, in a sense that things are run orderly, of course, within the parameters of my authority as advisor on matters of procedure. Thank you.
Sorry. And Mr. Klaksel, have you attended any State of the Nation addresses during your career?
Yes, I have. I have attended State of the Nation addresses, and specifically, I have played a role, advisory role, since 2005, or even before that, 2004. But specifically in 2005, when I became Undersecretary for House proceedings, I had to play a direct role, and I've been playing that role since then. Yes, I've been part of State of the Nation addresses.
And can you remember the date of the State of the Nation address for 2023?
In 2023, the State of the Nation address was on the 9th of February
Yes.
at 1900 hours.
Now, have you got a vague recollection as to how long the proceedings took that evening?
They would have taken more than an hour. You've mentioned vague recollection, certainly more than an hour. That's how long they would have taken.
Yes. It's not important the length of the time, because there's a specific incident which occurred during that State of the Nation address, which I'd like to ask that the parliamentary advisors play on the screen. And I'd like, once that's so, for you to comment on what you see and whether you have any knowledge of what you see with reference to the specific individuals in the clip. So may I ask that the clip be played? Thank you. Chair, we're just waiting for the IT to produce the clip. If the committee could bear with the evidence for a moment. Chair and the committee members understand that they're trying to resolve the glitches that are occurring. If the committee members could just bear with me or bear with the witness for a second or two. Thank you. Chair, I'm asked to ask whether those on the Zoom platform can see and hear the clip that's now being shown. So perhaps, Chair, if you could indicate what they can see, those on the Zoom platform. Yeah, are those on the Zoom platform? May I ask whether those can see and hear that which is being shown? We in Parliament can see it on the screen. It's not clear to us that those on the Zoom platform can also see and hear that which is being shown.
Through you, Chair, we are able to see it. Thank you.
Through you, Chair, we can see, but we can't hear. There's no
I
sound.
understand that the sound is problematic, but we'll show the clip and the witness can talk to what he's heard and what he's seen from his personal experience. Thank you. Mr. Council, perhaps you can tell the committee in your own words what you remember of the evening and at that particular point during the clip, whether you can identify any of those members of the National Assembly who behaved in the way that they did, and you can explain to the committee exactly your memory of what happened.
Thank you, Chairperson. What happened here, points of order were raised by honorable members. And of course, the speaker got to a point where she had to tell members to refrain from raising what she considered to be spurious points of order. And after there was some persistence in terms of interjections and what the speaker considered to be disruptive behavior and spurious points of order, the speaker then ordered certain members to leave the chamber. And these members refused to leave the chamber. And the speaker, of course, in terms of the rules, asked the Sergeant at Arms to approach the members so that they could leave the chamber. And of course, initially there was a refusal to leave the chamber. And following that, members were beginning to leave the chamber. At least that's what we thought was happening. And as we're observing that activity, 6 members of the Economic Freedom Fighters stormed the stage. I'm saying stormed because one member at least, some jumped onto the stage. And these members who were on the stage were Honorable Malema, were Honorable Shivambo, were Honorable Pambo, Honorable Dlamini, Honorable Ndlozi, and Honorable Tambo. That were
interject. Do you recognize those 6 members with you independently of having seen the video clip? Do you know them? Do you know who they are, those 6 individual names? And do you remember them from that particular evening?
Yes, I do. I work with the honorable members as secretary to the House, so I'm familiar. I know the members. At least I know their faces. I may not have met personally some of them, but I know their faces. I know the members very well.
Okay. And you say you remember though, it's your memory. Do you remember those 6 members having ascended onto the stage?
I remember seeing those members on the stage, yes.
And who else was on the stage? Well, let me ask you, who was on the stage at the moment that the 6 members, in your words, ascended onto the stage or stormed onto the stage?
You had the Honorable Speaker and the Honorable Chairperson of the National Council of Provinces, the President of the Republic, and of course you had us as the support staff, Secretary to Parliament, myself, Secretary to the National Assembly, Secretary to the National Council of Provinces, a procedural advisor in the Council of Provinces, Ms. Vuyokazi Mnana, and of course, a few other colleagues, Sergeant at Arms and others who were around, but the ones who were specifically doing business there are the ones that I've mentioned.
Now, you heard this morning. Sorry, Mr. Glassall, you heard this morning a debate between myself and counsel for the affected members on the issue as to whether the test for a charge of threatening the president and the presiding officers is objective or subjective. Now, obviously, you can't sit in the mind of somebody else, and you can't identify what was in the president or the speaker's mind, or at the same time, you can't know what was in the mind of those who were ascending to the stage. But you can tell the committee what your impression and the inferences that you can draw from the conduct, the body language, the timing, and other surrounding circumstances in respect of the conduct of those who ascended onto the stage.
The way proceedings of Parliament are conducted, there's element of order in which things are done. So you speak only when recognized by the speaker. You go to the podium when called upon to do that. Now, what happened in this instance is that, as I said earlier on, the observation was that members were leaving the chamber. And suddenly, some of the members ascended onto the stage. Of course, that was the manner in which it happened, obviously, was unprecedented, because it was not like calmly going onto the stage. Even that would have been out of order. But in this instance, it was abrupt. Of course, it was spontaneous. It was unsanctioned by the presiding officer. So certainly myself being on the stage that day, playing the role that I was playing, I was taken aback because, one, I did not expect it, and I certainly felt uneasy. So that is really what happened. And because the rules say that in the event of violence or a reasonable prospect of violence or serious disruption ensuing in the chamber, that is Rule 12, sub-rule 12 of 14 GA, in the event of serious disruption in the chamber as a result of member resisting to be removed, the presiding officer may suspend proceedings. So, because there was a sense that what was happening was unprecedented, it was not sanctioned by the rules, and the speaker took the actions that she took precisely because she felt also that the manner it happened was in breach of the rules. So, in my view, there was a disruption in the House, and the manner it happened, it was very disruptive and disorderly because that's not how it's supposed to happen. Thank you.
And from your evidence, I understand that the 6 members ascended onto the stage without the authority to do so. Is that correct?
No, there was no authority to do so. Speaker had asked members to leave the chamber. So there was no authority for members to be on the stage at that time. The person who was expected to be on the stage was the President of the Republic speaking.
And was it only the President who was entitled to be on the stage at that particular moment?
Apart from the other role players that I've already mentioned, it was a President who was expected to actively play a role at the podium at the time. Yeah.
Now, the last question I want to pose to you is this. Were the President, the Speaker, or other role players on the platform to have felt, and these are the words in the charge, that they were being approached in a threatening manner? And one sees that from the charge sheet. Would that have been a reasonable perception by the President of the Republic of South Africa and the presiding officers for them to perceive that they were being approached in a threatening manner?
I think I need to contextualize this by saying, firstly, I don't know what was in their minds, but certainly the manner in which things happened. One, I said it was unprecedented. 2, it was disruptive, and therefore it would be reasonable to say that the manner in which happened, it was threatening. But certainly I don't know what the President felt. I don't know what the Speaker felt at the time. I can only talk about the impression, reasonable impression that I got when this thing was happening. Of course, I mean, the word threat, you can view it in various and in different ways. It could also mean hostile action. It does not necessarily mean assault or anything. Yeah, always, all the time. Thank you.
The Chair and the other committee members, I have no further questions of this witness. And unless there are any questions that the committee members or the Chair, you yourself, with respect, wish to ask of this witness, I suspect the witness would request to be excused. Let me just add that he will be the only witness that we intend calling, and that would be the closer of our case. Thank you, Chair.
Thank you, Initiator. Honorable members, I don't know whether you do have questions. From the witness. My staff members assist of honorable members, if there are any.
I do apologize. May I ask the witness one more question, just to close the potential gap, and that is the events that on the 9th of February 2023 took place in the City Hall of Cape Town. Could you just explain why that happened, and can you also explain to the committee that the City Hall was designated to be a precinct of Parliament in terms of Section 2(1)(d) of the Act?
Thank you so much. The proceedings happened at the City Hall because the National Assembly is not available. The building was burnt down. And I would like to just read Section 2 of the Powers and Privileges Act in that regard. The precincts of Parliament is the area of land in every building or part of a building under Parliament's control. The chambers in which the proceedings of the houses are conducted, and galleries and lobbies of the chamber, every part of the building in which the chambers are situated, in every forecourt, yard, garden, enclosure, open space, appurtenant thereto, committee rooms and other meeting places provided or used primarily for Parliament's purposes, every other building or part of a building provided or used in connection with the proceedings of Parliament. So in terms of 2.1d, the City Hall constituted a chamber or the precincts of Parliament for the SONA meeting. Thank you.
Thank you, Chair. And lastly, once the 6 ascended onto the stage, could the proceedings, the State of the Nation address, continued, bearing in mind their ascending onto the stage?
It couldn't, and that's why it didn't at that point. Firstly, because in the view of the speaker, certainly there was disorder, grave disorder, and the rules are clear that in that event, the proceedings could be suspended. And so once the proceedings were suspended, once that happened and the proceedings were suspended, the sitting could then not continue. And of course, they could only resume once order was restored. Yeah, I may repeat if I need to. I may repeat what I was saying if I need to.
Do you want to add something, Mr. Clausen?
No, I'm done. Yeah.
Madam Chair, I have no further questions of this witness. And as I've said, once this witness is excused, we would. Yes, thank you, Chair. I have no further questions of this witness. And once this witness is excused, the initiator will close its case and we will ask for a short indulgence as to when we present closing arguments to the committee. The suggestion that has been proposed by those assisting me is that we prepare a written document and that we present closing arguments till tomorrow morning. But I think what I'm now saying is premature because the witness is still in the witness chair and perhaps he should be excused before I make those proposals. Are there any questions of this witness by the committee members or by the chair?
Thank you, Initiator. Honorable members, do you have any question? Honorable Dr. Tlafe.
Thank you, Chair.
Yes, I have seen your hand. I'm recognizing you too.
Thank you, Chair. Thanks for the opportunity. I just want to ask 3 questions that are interlinked to the Secretary of Parliament. One, as the Secretary of Parliament, what inferences are you making on that incident when members of Parliament ascended the stage, as it was indicated that they were not authorized to do so? Number 2, the initiator is indicating on the preamble that on that evening there were dignitaries, members of judiciary, except only for members of Parliament that were there. What impact do you think this incident is having in terms of a parliament on the dignitaries that has been indicated there. And the other one is that, according to you and your experience, what do you think such incidents has impact on ordinary members of parliament and South Africans who were watching or who were present on this evening? Thank you, Chair.
Thank you, Dr. Trapper. Let me recognize Honorable Mlenzan.
Yes, good afternoon, Chairperson. You will excuse me for the background, but I'm trying. I think I'm fine now. Just one question, Honorable Chairperson and colleagues. It's around security. It's gone to the Secretary in the main. My understanding is that from the President down to whoever dignitaries as mentioned that were part of the State of the Nation address, they have got security personnel attached to them whilst outside the presence of Parliament. What happens when they are within presence of Parliament, particularly inside the chambers? Who's responsible for the security of the President and dignitaries? Thank you.
Thank you, Honorable Mlenzana. Any other hands?
Ms. Majosi.
Yes, Honorable Majosi.
Thank you, Honorable Chairperson. Again, greetings to all honorable members and everyone who is present today. My question would be one, Chairperson. I would like to know from Mr. Kaso, ever since he joined Parliament, has something like this ever happened before? And if yes, then how was it handled? And maybe if not, is it something that he has experienced the first time? Maybe if he knows history even before he joined Parliament, maybe has it ever happened before he joined? And I would like to know that, and so that we know then that it is something that has never happened, and how are honorable members supposed to handle themselves when they're in the sauna, so that he explains that to us, and then we get a clear picture maybe before I go forward. Thanks, Chair.
Thank you, Honorable Majosi. Secretary, can you respond to the three honorable members?
Thank you, Madam Chair. The one question by Honorable Tlhape, my response would be as follows, honorable members, that the State of the Nation address is convened in terms of the Constitution, Section 84(2)(d), which empowers the President to summon the National Assembly and National Council of Provinces to an extraordinary sitting to conduct special business. But you also need to see it within the whole framework of the Constitution. It's really about the issue of accountability and oversight. It's the executive coming to account to Parliament in terms of the state of the nation, and it's not an event. And Parliament holding the executive accountable in line with the assertions that the President would have made during the State of the Nation address. Hence, you would have State of the Nation address, you would have the budget, And then you have committees focusing on certain priorities that were announced. But apart from that, it is one event where you don't only have just the executive and the legislature. You also have the judiciary in attendance. That's why it's called State of the Nation Address. It's not just about the government, but the state. But apart from the three arms of the state, you also have other dignitaries, like foreign dignitaries attending. So when something like that happens, if suppose this program would have collapsed and did not continue, that accountability exercise would have been affected. So any disruptive exercise by anyone, whether it's members of parliament or any other person who seeks to interfere with the functioning of the business of parliament in an orderly function. When I say orderly, I just mean in terms of the rules. It would have a detrimental effect on the ability of parliament to carry out its constitutional functions. So that is why the presiding officer would have reacted the manner they reacted on the day. Security personnel, Section 4 of the Powers and Privileges Act, I think it is, no, Section 3, the Speaker and the Chairperson exercise joint control and authority over the precincts on behalf of Parliament. So within Parliament, the Speaker and the Chairpersons, they also exercise that authority. Hence, the rules would empower them, when appropriate, to call upon the security services to take part in something that is happening in Parliament. So I think that takes care of things. Honorable Majosi asked, has something like this happened before? Obviously not the same, but we've had instances before. One was many years ago, it was members of the public who had placards in the gallery, and they were summarily removed. But we've also had in 2014 where members of, it was a question session, it was not a joint sitting, obviously, and that sitting could not continue because members staged a protest. But in 2019, it was a budget vote on public enterprises. I think it was in July, could be the 13th or 12th, the date, when members refused that a minister should speak, and they stormed the stage, and there had to be a human shield around the minister. And of course, that case ended here in this committee, and the committee dealt with the matter. And again, in 2019, I remember members who had placards, but they did not storm the stage in the House, National Assembly. But this one, in a sense, is you had members storming the stage in a joint sitting in that manner that it happened. So it had never happened in that same fashion before. So they were the first of its kind to happen. Thank you, Honorable Chairperson.
Thank you, Secretary. Honorable members, any follow-up question?
Chairperson Lenzana here.
Yes, Honorable Mlenzana.
Now, my follow-up question would be if Mr. Castle could justify following what he has explained in terms of the responsibilities of both the Speaker and Chairperson of the Federal Council of Provinces in terms of the discharge of security personnel. Can he justify the calling of security inside the chamber?
Over to you, Secretary. Can you do that?
Thank you so much, Chairperson. What I can explain is that the rules do make provision for the Speaker to call upon the security services when there is a reasonable prospect of violence or threat or disruption, serious disruption, that's what the rule says, serious disruption of proceedings. And that is the justification. It's not my personal justification, but it's the rules that justify that. So when the speaker has made a determination that there is prospect, I think that is important. It does not say when there is violence, when there is prospect of violence or serious disruption. In fact, let me read the rule rather. In the event of violence, it's Rule 14GA12 of the Joint Rules. In the event of violence or a reasonable prospect of violence or serious disruption, in other words, reasonable prospect of serious disruption ensuing in the chamber as a result of member or members resisting removal, the presiding officers may suspend proceedings, and the members of the security services may be called upon by the speaker or the chairperson to assist with the removal of the members. So that's really what the rule says on that score. So that is really the justification. It's found in the rules. Thank you, Chairperson.
Thank you, Secretary. In the absence of follow-up questions, I would like to thank the initiator.
Chairperson, I have a question.
Okay. Honorable Ledrick.
Thank you, Chair. I would just like to know, Mr. Kastu, in terms of your understanding the rules and the legislation, what comprises security services in that specific kind of instance, for example, a SONA? Thank you.
Thank you so much, Chairperson. In terms of the law, Powers and Privileges Act, the definition of security services is contained in Section 199 of the Constitution. I'm just going there now with your permission. So just to assist the honorable member, it's in the definitions clause of Section 1 of the Powers and Privileges Committee Act, which says security services means those referred in Section 199 of the Constitution. So here, I'll see if I can just read the ones that are relevant. At Section 199 now. Security services of the Republic consist of a single defense force, a single police service, and any intelligence services established in terms of the Constitution. So here, this is really, it's broad to include any of those that could participate in these activities. Chair, thank you. So this is not, maybe I should just make this distinction. There is parliamentary protection services, which is an internal mechanism, protection mechanism within Parliament that is distinct from your security services, which generally in Parliament, what you would find is police. So they would fit in that definition of security services of the Republic. Thank you, Chairperson.
Thank you. Any follow-up question, Honorable Lodrick? Are you fine?
Yes, thank you, Chair. Honorable Chair.
Yes, Deputy Chief Whip.
Thank you very much, Honorable Chair. Just one question for Mr. Kasu. Has this conduct of the EFF members, in your opinion and experience, negatively impacted on the decorum and the dignity of the House?
Thank you.
Thank you.
Honorable Chair, my response would be as follows. Any conduct that has a potential to prevent the House by anyone from performing its functions, whether it is about preventing a member from proceeding to the House or preventing a member from speaking, that would be in violation of not just the privilege, not just the decorum, but of course the privileges of the House. So I would like to, with your permission, Chair, to be as general as that, because remember, mine here is just to explain the rules and the procedures of Parliament. It is for this committee to decide whether what happened on the day harmed the decorum of this House or did not harm. It's really not for me to express an opinion there. All I know is that there are rules in place that must be observed, and I am expected to observe those rules. I cannot, for instance, as an official, just go and address the House because I don't have speaking rights in the House. And that behavior would not be in line with the rules. But Chair, with your permission, I will not express an opinion on what is likely to be the finding of this committee on the matter. I just express a view on the application of the rules. Thank you.
Thank you, Secretary. Thanks for the explanation. I believe we are together with other honorable members. Yours is to clarify the rules to allow us to come to a particular determination. You are right. And also to give evidence or witness what we have seen. Thank you so much, honorable members. In the absence of any other question, I would like to thank all of you, the initiator, as well as our witness. And then at this stage, the committee meeting is adjourned for today and will resume tomorrow at 11 o'clock, not at 10 o'clock. I'm requesting that because of certain reasons. The meeting stand adjourned. Thank you.
Thank you, Chairperson.
Thank you, Chair.
Thank you, Deputy Chief Whip.